I call Eugenie Sage, 5 minutes.
Support of the Civil Defence Emergency Management Amendment Act 2016 Amendment Bill. Like the Honourable David Parker, I was a little surprised that there is this gap in the law, given that the Principal Act, which was before the Parliament only recently, allows a huge range of powers during the transition period to carry out works, to clear roads, to evacuate premises and places, to close roads and public places, to give directions to stop any activity or take any action, to limit the consequences of the emergency. And yet it didn't have this power to direct an owner of a building to carry out a building assessment to ensure that the building was safe after an emergency, or if things changed after the emergency, such as there was another aftershock. So it is a very sensible change to the Principal Act, because at the moment the only obligations are really under the health and safety legislation for building owners that are places of work to have to identify and manage hazards in a place of work, and under the Residential Tenancies Act, so that landlords must check the premises that they own after an earthquake to ensure that it is safe for tenants to remain. And the building owners may not be aware of the detail and the type of the assessment that is needed, and there is no centralised register really of which gives an understanding for authorities of whether buildings have been assessed or not. So this bill has a major advantage in allowing the controller during the transition period, such as a council, to actually require these assessments to be done and then to collate this information. And that's quite critical, Mr Speaker, because the council may be very aware of certain types of buildings, like buildings of a similar design to the CTV building in Christchurch, which are quite vulnerable and more prone to collapse. And it will enable councils to actually, and particularly here in Wellington, to require that these more detailed assessments are done if they are aware that there may be systemic issues in certain types of buildings that make them liable to partially or fully collapse in an earthquake. So in terms of property owners, they may see that this is a slight encroachment on their rights, but no one wants on their conscience owning or managing a building which causes death or injury in an earthquake. So it is the Parliament acting collectively to ensure that we fill this gap in the law and that we do everything that we can to protect all of ourselves, all citizens, in the event of continued earthquakes and other natural hazards. So, Mr Speaker, the Green Party supports this bill, and as my colleague Jan Logie explained, while we don't normally support bills going through under urgency, the continued sequence of aftershocks after the Kaikoura earthquake means that there is an urgency, a real urgency, in filling this gap in our law.